Hello my dearest friends, and welcome to ukvisasuccess.com. In today's video I am going to explain the rules regarding your absences from the UK and how this may affect your application under the EU settlement scheme. Let us begin. Before I explain the rules about absences from the UK, it is absolutely crucial for you to understand why this is important. It is important because in order for you to qualify under the EU settlement scheme, in addition to a number of other requirements, you will need to show that you have resided in the UK for a continuous qualifying period. The length of this continuous qualifying period will depend on the type of your application. It can be somewhere between 1 day to 5 years, let's say. And what you need to know is that this continuous qualifying period can be interrupted by your absences from the UK. Let me give you an example. Let's say you are an EU national and you would like to apply for a settled status under the EU settlement scheme. And for your particular category, in order for you to qualify for a settled status, one of the requirements which you will need to satisfy is that you have resided in the UK for a continuous period of 5 years. And you believe that you satisfy this requirement because you have resided in the UK for 5 years, so you make an application. However, instead of a settled status, which you were expecting to get, you receive only a pre-settled status. It's also known as further leave to remain. And in the decision letter, they've explained to you that you have breached the continuity of your residence in the UK by an 8 months absence from the UK, which happened between year 3 and 4. And as a result of this absence, your time for the purposes of obtaining indefinite leave to remain under the EU settlement scheme, which is also known as a settled status, will only start from year 4, from here. And for you, this is a bad news because you will need to wait for another 3 years. So it starts from year 4. So it's 2 years you've done already. So you need to wait for another 3 years before you become eligible for a settled status. And I've created this video to help you check if such a decision is correct and to make sure that you are fully aware how your absences will affect your right to remain in the UK under the EU settlement scheme. Generally, the continuity of residence can be broken by 3 events. The first one is when the person is absent from the UK for more than 6 months in any 12 months period of time, and there are some exceptions which I'll explain a little bit later. The second one is when the person served or is serving a sentence of imprisonment of any length in the UK or Ireland, and the last one is when one of the following decisions has occurred and they were not set aside and they're still in effect. The first one is any decision or order to exclude or remove a person from the UK. The second one is an exclusion decision, and the third one is when the person has got a deportation order against them. With regards to absences, as I said, the continuity of residence will be broken if a person is absent from the UK for 6 months or more in any 12 months period of time, unless these 3 exceptions apply. First of all, when there is a single period of absence which did not exceed 12 months and was for one of the following important reasons, such as pregnancy, childbirth, serious illness, study, vocational training, or an overseas posting. Second one is when there was absence for any period of time for the reasons of compulsory military service. And the third one is absence for any period of time due to a posting on Crown service, or where there was a spouse or a civil partner, durable partner, or a child which needed to go because their parent or their partner was on a posting for the Crown services. And this is what they accept. First of all, when the person was a member of the HM forces. The second one is an employee of the UK government and Northern Ireland Department, the Scottish administration, or the Welsh government. And the last one is a permanent member of the British Council. So going back to our example over here, the continuity of residence will not be broken and you will qualify for indefinite leave to remain under the EU settlement scheme if your 8 months absence from the UK was for one of the important reasons such as pregnancy, childbirth, serious illness, study, vocational training, or an overseas posting. So if you have one of these reasons when you were absent from the UK for more than 6 months, when you submit your application under the EU settlement scheme, please make sure to include with your application a letter explaining your personal circumstances together with an official document confirming your reasons for absence for more than 6 months. This can be a letter from the school or a hospital or employer. It depends on your circumstances. Guys, if you're watching this video, you probably want to know more about the EU settlement scheme and how you can apply. And if you visit ukvisasuccess.com/EU and tell me where I can send further information, I'll send you an email with some helpful information regarding the EU settlement scheme. And you'll also get a free access to a masterclass on how to avoid 2 most common mistakes in the EU settlement applications. It consists of 3 videos which you need to watch if you want to succeed in your application under the EU settlement scheme. If you found this video useful, you can do 3 things right now. You can subscribe to my YouTube channel. You can visit my free website at ukvisasuccess.com. And most importantly, you can share this video with those who may benefit from it. By sharing these videos, you may help others avoid refusals of their immigration applications. Because in immigration law, knowledge and clarity are the key ingredients to success. Thank you so much for your support and for your positive feedback, which incredibly inspires me and gives me fuel to create more and more videos clarifying various aspects of UK immigration law. Have a great day, everyone.